On a motion to judicially settle a final account of a guardianship, does the court need to order a hearing and grant disclosure? To find out, you have to read Matter of Giuliana M, but it's 3 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I normally cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is an episode, part of a limited series I'm doing on cases relevant to elder law and estate planning issues. This is a Second Department Appellate Division case, an important recent case from October 18th of 2023 by the name of Matter of Giuliana M. The citation for this case is 2023 New York Slip Opinion 05262. And the issue in this case is a guardianship kind of a case. The issue is whether a court needs to order discovery and order a hearing when there's objections filed to a motion to judicially settle a final account for a guardianship. To understand and appreciate the context of this case, you have to understand briefly that when there's a guardianship, when a guardian's been appointed for a person, one of the rules of the guardianship, one of the parts of the statute is that within 150 days of the death of the incapacitated person, the person for whom there's a guardian appointed, the guardian is required to file a motion to judicially settle the final account, and basically goes over everything that the guardian has done from the moment the guardian was appointed to the present. And that's under MHL 8133. And that motion has to be served upon all the interested parties, prospective beneficiaries, people listed in the order and judgment. And when the court grants that order settling the final account, it relieves the guardian of any further liability. From the moment the guardian is appointed, they are an officer that's responsible, has liability for what's going on in the guardianship. That order settling the final account is what ends that responsibility on the part of the guardian. So what are the facts here? The facts are that in 2018, Joseph O. commenced a guardianship proceeding under Article 81 for a person he knew named Giuliana M. And part of that petition under Article 81 was an allegation that Giuliana M's family was misappropriating her money for their own benefit. So he wins the application, but the Supreme Court grants a guardianship, but does not appoint Joseph O. as the guardian. Instead, appoints a person off the Part 36 fiduciary list, appoints attorney Anthony DeCarolis as the guardian of the property. The court ordered the guardian to conduct, one of the powers the guardian had and responsibilities was to conduct an investigation into these allegations of misappropriation by the family, and if necessary, to commence a turnover proceeding under Article 8143, which would allow a guardian to seek reimbursement for monies that were unlawfully or inappropriately taken from the incapacitated person. Giuliana M., the incapacitated person, died on March 7th of 2020. So within 150 days now, the rule requires the guardian submit a final accounting, a motion to judicially settle the final account. So he did. Guardian DeCarolis moved to judicially settle the final account, and Joseph O., that original petitioner, filed objections to that motion, including objecting to the guardian's request for fees, disbursements, and sought to have the guardian surcharged for failing to adequately investigate those misappropriation allegations. In December of that same year, the Supreme Court decided the motion without a hearing and granted the application to judicially settle the final account. At that point, the procedural history is Joseph O. moved for discovery to pursue his allegations and to vacate the order. The Supreme Court denied the motion. It goes to the appellate division. And here we have a decision. The decision addresses 2 things. First, with regard to whether the hearing should have been conducted or whether the court was wrong to settle that final account without a hearing. And the second issue is about the discovery. As to whether the court should have just conducted a hearing instead of just granting it without a hearing, the appellate division holds that any objectant to the settlement of a final account has a burden of coming forward with evidence to establish that the amounts sought are inaccurate or incomplete. If the objections raise disputed issues of fact, then a hearing must be held. That's the holding here. Here, the objectant raised issues. There were disputed issues of fact, and the Supreme Court did not hold a hearing, just signed off on the order settling the final account, dismissing the objections. That was error, according to the appellate division. A hearing had to have been held. And with regard to discovery, they say that discovery generally on special proceedings is not, it's only available upon leave of the court because special proceedings are expedited proceedings. But they say that, and they say the court should grant it only when there's a need. And that need has to be balanced against the opposing interests of expediency and confidentiality. Here, the appellate division says, Joseph O. demonstrated that there was a need for material and relevant information, and there was no showing on the other side of that it would be unduly prejudicial or unduly burdensome or violate confidentiality, and therefore the Supreme Court erred in that as well. The Supreme Court should have ordered discovery and separately should have ordered a hearing. So that's the case of Matter of Giuliana M. This is important because this is in the context of a post-death motion where the next stop is going to be surrogate's court. So this talks about the ability to get discovery and a hearing before even going to surrogate's court, where other proceedings would be available or different proceedings would be available. So that's the case of Matter of Giuliana M. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.